Hello, I'm Jane Tenquist, partner and head of the family team at Myerson. Currently, we have 4 solicitors in the team and a trainee solicitor. How are assets divided on divorce? The court has a wide discretion to distribute assets as fairly and as reasonably as it can between the parties. There's no catch-all formula. Each case is determined on its own special facts. The court gives first consideration to the welfare of any child of the family under the age of 18 years. The court has a statutory duty to consider to what extent it's possible to ascertain whether the parties to the marriage can become financially independent of each other at the time of the divorce or as soon as possible thereafter. The court will also have regard to what is known as the Section 25 factors when considering how to divide assets on divorce. The court will look at the length of the marriage, the respective ages of the parties to the marriage, whether there are any children of the family, whether there are any relevant health considerations which affect a person's ability to work, the standard of living enjoyed during the course of the marriage, the income and earning capacity of the parties to the marriage and the potential for improvement in the future, the capital resources of the parties to the marriage, the conduct of the parties in exceptional circumstances if it is so significant that it would be unfair to ignore it, and the value of any benefit which, by virtue of the divorce, any party would lose the chance of acquiring an interest in. Are assets divided equally on divorce? Sometimes, but not always. In a short, childless marriage, for example, it would create unfairness to divide assets equally. In those circumstances, it may be more appropriate that each party leaves the marriage with what they brought into it. However, in a medium or long-term marriage, when the wealth has been generated during the course of the marriage, it may be more appropriate to divide assets equally. Each case is determined on its own facts. It is important to consider whether assets accrued prior to marriage or post-separation, whether assets were inherited or gifted to one party to the marriage, or whether a prenuptial agreement or postnuptial agreement was ever entered into by the parties, which may affect financial entitlement on divorce. What are matrimonial assets? These are assets built up by either party to the marriage during the course of the marriage. It is usually include the house, where the parties have lived together as husband and wife, regardless of whether the party is registered in one of the parties' sole names. These are usually divided equally. What are non-matrimonial assets? These include gifts or inheritances to either spouse from a resource outside the marriage or property acquired prior to marriage. This property will not be shared equally between the parties to the marriage, save to meet needs. The most effective way to protect non-marital assets prior to marriage is by way of a prenuptial agreement. It may also be possible to protect assets acquired during the course of the marriage by way of gift or inheritance by entering into a postnuptial agreement. What is a clean break? The court has a duty to consider to what extent it is feasible for the parties to the marriage to become financially independent of each other at the time of the divorce or as soon as possible after the divorce. A clean break order means that there is a financial settlement which does not provide for ongoing maintenance payments to either spouse. What is spousal maintenance? Spousal maintenance means a regular monthly sum of money paid by one party to the other to cover living expenses and household bills. There is no statutory formula to determine the amount payable. Generally, spousal maintenance orders can be for a specific period of time to allow a spouse to adjust financially to the breakdown of the marriage and give them sufficient time to re-establish a career and become financially independent. However, sometimes this may not be possible, and a longer period of maintenance may be more relevant if, for example, one party needs to stay at home to look after the needs of the young children, or if a spouse is able to demonstrate that it is financially impossible for them ever to become financially independent. How can we help? All the solicitors in the family team at Myerson are members of Resolution, which is a national body of family lawyers who are committed to resolving family disputes in as non-confrontational a way as possible. All our solicitors have accreditations and extra training in complex financial remedies, injunctions, and private children work. We actively encourage mediation and other out-of-court options to resolve difficulties on relationship breakdown. However, we do not shy away from issuing court proceedings when this is necessary to protect the client's interests. Myerson is not a niche family practice. It is an all-service law firm. We work closely with other specialist solicitors in other departments to ensure that solicitors receive the most commercially sound advice when considering how divorce affects their business, their property rights, their private wealth and trust issues, and their income. We appreciate that the breakdown of a relationship is a very upsetting time, and it's often difficult for emotional and financial reasons. At Myerson, we have excellent links with personal counsellors to assist clients during this process. If clients are struggling to pay their legal fees, we may be able to assist them by applying for a litigation loan on their behalf, which is typically repayable at the end of the litigation.